Same-sex marriage first became a significant issue in the United States back in the early 1970s. That was a time when people were asserting a lot of new rights: civil rights, women's rights, students' rights, prisoners' rights, and so on. And it was a time when people were arguing for gay rights as well. The Stonewall Uprising was in 1969, and people were talking about the issue more, forming organizations like the Gay Liberation Front, and being inspired to stand up for themselves and make legal claims about their rights.
In the early morning hours of June 28, 1969, a riot broke out in front of the Stonewall Inn in New York City. The violent protest became known as the Stonewall Riots. The Stonewall Riots were a watershed moment in the gay rights movement, sparking activism and awareness across the United States.
There were a number of lawsuits filed back in the early 1970s in which same-sex couples asserted that they had a right to get married. All of these claims were unsuccessful. Courts pretty much summarily rejected the arguments. I don't think it was seen as even being a plausible idea. At that time, even among advocates for gay rights and equality, it was controversial whether they should even raise the issue of marriage. Some said, hey, everybody should have a right to get married. But others said, it's just not something worth focusing on. It will provoke a backlash, and we'd be better off focusing on more achievable goals, like trying to reduce discrimination in employment or housing or things like that. The U.S. Supreme Court issued a very short ruling in one of the cases about same-sex marriage in the early 1970s. It was a case called Baker v. Nelson, a case brought by two men in Minnesota who applied for a marriage license and were denied. The Minnesota Supreme Court had ruled that there is no fundamental constitutional right for same-sex couples to get married. The case was appealed to the U.S. Supreme Court, which rejected the claim with a one-sentence decision. It just said, the appeal from the Supreme Court of Minnesota is dismissed for want of a substantial federal question. So the court said this just wasn't even a substantial, plausible claim. Around the same time, there were a few states that enacted laws defining marriage as being allowed only for a pair of people consisting of one man and one woman. Maryland was the first state to enact such a law, which was passed in 1973. Prior to that time, it just wasn't an issue that anyone had paid much attention to, so there were no laws about it one way or the other. So for about 20 years, through the 1970s, into the 1980s, and even into the early 1990s, same-sex marriage really was not a high-profile issue. It was not on the radar screen of many people. That changed in 1993 when the Supreme Court of Hawaii broke new ground with a ruling in favor of same-sex marriage. The Hawaii court did not reach the point of saying that there was a right to same-sex marriage, but they hinted that they were headed in that direction. The case was based entirely on Hawaii's state constitution, not the U.S. Constitution. And the judges analyzed this as a matter of gender discrimination, which is something that gets strict scrutiny under Hawaiian law. So the court said strict scrutiny would apply, and they remanded the case to the lower courts to apply that scrutiny and to decide if Hawaii had a compelling reason for not allowing same-sex marriages. The litigation was interrupted, however, by new developments. Before the courts had finished deciding the issue, their consideration of it was superseded by an amendment to the Hawaii state constitution. The amendment basically ended the matter and said that there would not be same-sex marriages allowed in Hawaii. So the events in Hawaii were like a false start. It seemed like there was going to be same-sex marriage there, but then it worked out differently. But nevertheless, the Hawaii situation made same-sex marriage a big issue all over the country. People were talking about it. There was a wave of litigation about it in other states, and there was also a lot of legislative activity. And the issue started being raised in other countries as well, around the world, both in courts and in legislatures. So eventually, you wind up with same-sex marriages being permitted in a number of states, gradually more and more over the years. There were several states, like Massachusetts, Connecticut, and Iowa, where it happened through court decisions. Courts said that same-sex marriage should be allowed. Those rulings were based on state constitutional law, which meant the U.S. Supreme Court could not review the validity of those decisions. And then there were some states, like Vermont, Maine, New Hampshire, New York, Maryland, Washington, where legislatures voted to allow same-sex marriage. There were also some other states where they took partial steps toward same-sex marriage, but did not quite go all the way to it. For example, in some states like Colorado, Nevada, Oregon, and Wisconsin, they allowed various kinds of civil unions or registered domestic partnerships that give you some or all of the same legal benefits of marriage, but without calling it a marriage. And on the other hand, there was a lot of legislative activity in the other direction. Many states passed statutes or state constitutional provisions, or both, that say a marriage can only be between a man and a woman. Again, there had been some laws like that passed back in the early 1970s, but there were more of them adopted in the 1990s, when this became an even bigger issue. There was also a federal law which was enacted in 1996 called the Defense of Marriage Act, and it said that same-sex marriages would not be recognized for any federal law purposes, like federal taxes, or federal employment benefits, or federal Social Security or Medicaid programs. And the law said that no state would be required to recognize the validity of a same-sex marriage from another state. So, for example, if a couple got married somewhere where it was permitted, like in Massachusetts, and then they moved to Missouri or Kansas or wherever, those states to which they moved would not be required to accept their relationship as being a valid marriage, even though it was legally recognized by another state where it had occurred. There were two important cases about same-sex marriage decided by the Supreme Court in 2013. One of them raised the basic, broad issue of whether there is a constitutional right to same-sex marriage. And in that case, the Supreme Court ruled in a way that avoided answering that question. The case was about California law, which prohibited same-sex marriage. But the state of California refused to defend that law. The governors of that state, first Arnold Schwarzenegger and then Jerry Brown, opposed the law, so they refused to have the Attorney General or other lawyers of the state defending it.
I always said that I have nothing against people doing what they want to do. If a couple wants to get married, they should get married. I personally always said that marriage is between a man and a woman, but I would never enforce my will on people. I always want people to make that decision. If they want to get married, let them get married.
Some private groups tried to intervene and defend the California law, but the Supreme Court said they weren't really proper parties and didn't have standing to bring appeals about the constitutionality of that law. So at that point, in that case, in 2013, the Supreme Court basically ducked the big question of constitutional rights for same-sex marriage. But the Supreme Court did make a more limited ruling in a second case called Windsor v. United States. It was about the federal law, the Defense of Marriage Act, that said that same-sex marriages wouldn't count for federal legal purposes, like federal taxes and employment and benefits like Social Security. The Supreme Court struck down that law. They said that the federal government did not have any sufficient justifications for disregarding same-sex marriages.
In short, the Act's demonstrated purpose is to ensure that if any state decides to recognize same-sex marriages, those unions will be treated as second-class marriages for purposes of federal law. By creating two contradictory marriage regimes within the same state, Section 3 of DOMA forces same-sex couples to live as married for the purpose of state law, but unmarried for the purpose of federal law. This diminishes the stability and predictability of basic personal relations the state has found it proper to acknowledge and protect. No legitimate purpose overcomes the purpose in effect to disparage and to injure those whom the state, by its marriage laws, sought to protect in personhood and dignity. By seeking to displace this protection, and treating those persons as living in marriage as less respected than others, Section 3 of DOMA is in violation of the Fifth Amendment.
So in other words, at that point, the situation was that there was not a right to same-sex marriage. So if your state allowed such a marriage, that's fine. If a state did not allow such a marriage, that was fine. But if a state gave you such a marriage, then the federal government was obligated to accept it as being valid for federal law purposes. It seemed pretty clear that the Supreme Court was deliberately taking things gradually, one step at a time. The Windsor case was a 5-4 decision, and the majority, particularly Justice Anthony Kennedy, seemed to want to take things slowly, one step at a time. They made a ruling on the federal recognition of same-sex marriages, and then they could see how the nation reacted to that, and put off the broader issue for another day. But looking at the majority's opinion in Windsor, it seemed pretty obvious that when they did decide the broader issue, they were going to say that there was a constitutional right to same-sex marriage. It seemed pretty clear that they were headed that way. And in fact, in his dissent in Windsor, Justice Scalia took the unusual step of quoting many passages from the majority opinion in Windsor and then editing or marking them up to show how easy it would be to rewrite them to say that there was a constitutional right to same-sex marriage.
The result will be a judicial distortion of our society's debate over marriage. That debate is in no need of this court's clumsy help. Few public controversies touch an institution so central to the lives of many, and few inspire such attendant passion by good people on all sides. Few public controversies will ever demonstrate so vividly the beauty of what our framers gave us, a gift the court pawns today to buy its stolen moment in the spotlight, a system of government that permits us to rule ourselves. Since DOMA's passage, citizens on both sides of the question have seen victories and they have seen defeats. There have been plebiscites, legislation, persuasion, and loud voices. In other words, democracy. Victories in some states, for example, North Carolina, for the traditional definition of marriage have been offset by victories in other states, for example, Maryland, for same-sex marriage. Even in a single state, such as Maine, the question has come out differently on different occasions. In the majority's telling, however, this story is black and white. Hate your neighbor or come along with us. The truth is more complicated. It is hard to admit that one's political opponents are not monsters, especially in a struggle like this one. And the challenge in the end proves more than today's court can handle. Too bad. A reminder that disagreement over something so fundamental as marriage can still be settled democratically rather than by judicial fiat would have been a fit task for what in earlier times was called the judicial temperament. We might have covered ourselves with honor today by promising all sides of this debate that it was theirs to settle and that we would respect their resolution. We might have let the people decide. But that the majority will not do. Some will rejoice in today's decision and some will despair at it. That is the nature of a controversy that matters so much to so many. But the court has cheated both sides, robbing the winners of an honest victory and the losers of the peace that comes from a fair defeat. We owed both of them better. I dissent.
And Justice Scalia's forecast was correct. 2 years later, in Obergefell v. Hodges, the Supreme Court did hold that there's a constitutional right to same-sex marriage.
Good morning. My name is Jim Obergefell, and I'm from Cincinnati, Ohio. I've lived in Ohio for most of my life. My late husband, John, and I were together for almost 21 years before he passed away as a result of the complications of ALS. I'm here today in front of our nation's highest court because my home state fought the recognition of my marriage to John. And when the man I loved and cared for passed away from one of the cruelest diseases known to humanity, the state of Ohio, the state in which I've lived, worked, and paid taxes for most of my life, continued to fight my right to list my name on John's death certificate. No American should have to suffer that indignity. That's why John and I and the 30 plaintiffs who are part of this lawsuit decided to fight. I know in my heart that John is with me today. That man cared for and loved me for 21 years through thick and thin. Today's ruling from the Supreme Court affirms what millions across this country already know to be true in our hearts. Our love is equal. That the 4 words etched onto the front of the Supreme Court, equal justice under law, apply to us too.
The court primarily analyzed this as an equal protection issue, but there were substantive due process arguments as well. Arguments about the right of privacy and the right to marry. One of the things to realize about this issue is how it underwent a dramatic shift in public opinion within a relatively short amount of time. Back in 1996, only about 1/4 of Americans thought same-sex marriages should be allowed. The president at that time was Bill Clinton. He was a relatively liberal person on most social issues, but he opposed same-sex marriage. He not only opposed same-sex marriage rights, but he signed into law the Federal Defense of Marriage Act.
He had all kinds of gay friends, from fundraisers from California and so forth. So wasn't the gay community at the time surprised that he did this, or maybe not?
Oh, yeah, very surprised and very angry, a lot of people, obviously. That's what makes it such an interesting story, because Bill Clinton was really the first president to openly court the gay community, to openly embrace their priorities. He pushed for a workplace non-discrimination law. He had, as you pointed out, openly gay advisors. He pushed for AIDS funding. He tried to get the military to open its doors to gays and lesbians, didn't succeed, got a compromise that people didn't like called Don't Ask, Don't Tell. So when this came up, it felt like a betrayal, I think, to a lot of his friends who considered it an act of calculation.
Over the next decade, public support for same-sex marriage would increase significantly. For example, by the time Barack Obama became president in 2009, polls showed that about half of Americans thought same-sex marriages should be permitted. But President Obama offered support only for civil unions or domestic partnerships for same-sex couples, not marriage.
With respect to gay marriage, I do not support gay marriage, but I support a very strong version of civil unions where I think the state has to recognize the same rights and responsibilities for gay people, same-sex couples, as they do for anybody else. Because the state is not a religious institution, and I believe in equal protection under the law, and so making sure that the right to transfer property, hospital visitation, non-discrimination, all those principles apply to same-sex couples, I think is important.
But soon, President Obama said that his views on the issue were evolving.
In a stunning turn of events, President Obama told the Justice Department to stop defending the 1996 law that defines marriage as between one man and one woman. The president's been defending the law for 2 years, but today he called it unconstitutional.
And the feelings of many other Americans were evolving as well. By the time the Supreme Court made its decision in Obergefell in 2015, recognizing a right to same-sex marriage, public opinion polls showed that about 60 to 70% of Americans supported that decision. And the next president, Donald Trump, also shifted his position on the issue to some extent. When he was running for president in 2016, he said that he was opposed to same-sex marriage and would appoint Supreme Court justices who would overturn the Obergefell decision. But after taking office, he said that he was fine with same-sex marriage and believed the Obergefell decision had settled the matter.
But on another controversial issue, marriage equality, he said the issue of same-sex marriage is settled.
These cases have gone to the Supreme Court. They've been settled. And I'm fine with that.
So this is an issue where there has been a lot of change within a relatively short amount of time. And that change can be seen in data about public opinion. It can be seen in the positions taken by prominent political figures. And of course, it can be seen in the decisions of the Supreme Court.